So good morning, everyone, and welcome to this event to celebrate the 75th year of the Indian Constitution. We extend warm greetings on behalf of American Constitution Society, Center for Constitutional Governance at Columbia Law School, Institute for Comparative Literature and Society at Columbia University, and CEDE, which is based in India. Over the next 2 days, we are honored to host 2 sitting justices of the Indian Supreme Court who will engage with the audience on contemporary relevance and challenges facing the Indian Constitution. India adopted its constitution on November 26, 1949, marking a significant political milestone as the country transitioned to a sovereign republic. Rooted in the principles of justice and equality, the Indian Constitution aimed to dismantle oppressive structures such as caste and patriarchy. As noted by Granville Austin, a notable American historian of Indian Constitution, one of the overarching goals of the Indian Constitution was to catalyze a social revolution, bringing about fundamental changes in the very structure of the Indian society. To realize this vision, the Constitution established various institutions, most notable amongst which is the Indian Supreme Court, the ultimate interpreter of the Constitution provisions. As Austin observed, the provisions related to the judiciary in the Constitution were framed with a sense of idealism. Interestingly, this year also coincides with the 75th year of the establishment of the Indian Supreme Court. The Supreme Court serves as a lens through which one can observe India's working constitution, the challenges that it faces, and the numerous complexities with which it grapples. The Indian Supreme Court is therefore not only the interpreter of the Constitution, but is also instrumental in shaping the trajectory of India's social ethos. As Justice Nagarathna has noted, the Indian Constitution and the goals of the society are the very goals of the Indian Constitution. Today, we are honored to have this distinguished speaker with us who will address this important theme. Honorable Justice B.V Nagarathna, Judge of the Indian Supreme Court, will speak on the topic Indian Supreme Court and Social Justice, a 75-year-old history. But before we invite Justice Nagarathna to deliver this lecture, we are joined by Professor Anupama Rao, who will give the introductory remarks. Professor Rao is a professor of history and Middle Eastern, South Asian, and African studies at Columbia University. Her research and teaching interests include gender and sexuality studies, caste and race, historical anthropology, social theory, and colonial genealogies of human rights and humanitarians. She is the director of the Institute for Comparative Literature and Society, which is one of the co-sponsors of this event, and also the convener of Wadekar Initiative at Columbia University. I will now invite Professor Rao to give the opening remarks.
Thank you very much. Good morning and good evening to everyone. It's an honor to be here today to offer opening remarks to introduce the Honorable Justice B.V Nagarathna, who is slated to become the first female Chief Justice of India's Supreme Court in 2027, and to commemorate the 75th anniversary of the Indian Supreme Court. Now, the Constitution is a document whose legacy of social justice and due process, I believe the Honorable Justice B.V Nagarathna exemplifies. We're at a critical juncture in the history of Indian democracy and of democracy's global reverberations more broadly. And it's imperative that we consider the relevance of constitutions to democratic founding and to recommit to its fundaments in order to rejuvenate our collective public life at this point in time. I'd like to start by thanking the organizers of this event for inviting me, the American Constitution Society, the Center for Constitutional Governance, CEDE, the Committee for the Eradication of Discrimination in Education and Employment, and especially CEDE's founder, Disha Wadekar, for her relentless commitment to expanding our imagination of democratic possibility. As Disha noted, I serve as the director of the Institute for Comparative Literature and Society and as the convener of the Wadekar Initiative, which seeks to resuscitate the links, both implicit and explicit, between the world's oldest and the world's largest democracies through the figure of Columbia's native son, B.R. Ambedkar. The great constitutional thinker popularly referred to as the architect of the Indian Constitution for his signal role as the chairman of the drafting committee of the Constituent Assembly. Ambedkar is among the 20th century's most important thinkers who elaborated the global reach and relevance of the democratic tradition and its radical possibilities for remaking society. Ambedkar's identity as Dalit, a member of the so-called untouchable or outcast communities who've suffered historic discrimination, social stigma, and absolute exclusion from socio-political life, makes his biography all the more significant, of course. Now, Ambedkar's thought has only recently begun to receive recognition in our public culture and among scholars of political theory and intellectual history, working in global and metropolitan contexts or operating primarily in English. And indeed, there's an inverse relationship between the scholarly neglect of one of the 20th century's most significant thinkers, on the one hand, and Ambedkar's signal relevance to the story of Indian democracy and the rise of modern caste-emancipated selfhood, on the other. And this is especially relevant, it seems to me, if we reflect on the fact that Ambedkar articulated a theoretical, practical reading of the relationship between caste and Indian democracy, and thereby foregrounded the conundrum of ongoing existential suffering despite legislated redress. His own investment in exceptional subjects, the poor, Dalits, the scheduled tribes, and so forth, as also potentially the universal subjects of rights, right? The modal political citizen is a signal contribution to political thought. By investing law and constitution with the capacity to redress caste discrimination, Ambedkar's interventions effected an extraordinary transformation of the grounds of politics itself, and it did so through constitutional measures. And this is indeed the constitution that we inherit. In marked difference to the contentious incremental process of franchise expansion in the West,
आवाज नहीं आ रही बोलो उसको एक सेकंड में बोलता हूँ एक सेकंड यार
Mr. Nasser, can you mute it at your end? Can you please mute at your end?
Voice is not coming properly.
Can you not hear me?
Yes, now we can hear you.
Can you mute yourself?
Okay.
Because we're having, yeah.
Okay. Thank you. So as I was saying, this is the constitution that we inherit. And in marked difference to the contentious incremental process of franchise expansion in the West, the Indian Constitution instituted adult franchise in the context of mass illiteracy and myriad social inequalities. Another temporal compression was also evident. Enfranchisement and affirmative action policies were adopted nearly simultaneously in the Constitution, and we could compare this with the history of those similar processes in the US Constitution, for instance. And so while Euro-American liberal democracies have typically committed to the sanctity of procedure to guard against bias, India's emergent democracy specified desired outcomes. Vulnerable populations were inframed by a constitutional vision. The Indian Constitution recognizes unmarked citizens, right? The typical political citizen subject. But there are also, we also have named in the Constitution subjects defined by the markers of caste, poverty, and religion. The tension between economic empowerment, liberal individualism, and group equalization is written into the Constitution itself. And I'd like to take a moment to think a little bit about the last decade of Ambedkar's life, which is especially relevant in this regard. And speaking about it briefly will also help me transition to an introduction of today's speaker, the Honorable Justice Nagarathna, whose own identity and experience as a female justice ground an extraordinary record of commitment to the Constitution as a document enunciating the possibility for ongoing social justice. I'd like to place today's distinguished speaker in that genealogy of what I would call insurgent constitutionalism. So please bear with me for a few minutes longer as I mark the significance of our institution, Columbia, as well as the specific history of the law school, which brought Ambedkar back to New York to award him an honorary doctorate in law on the 5th of January, 1952, at the hands of then Vice President and Provost Grayson Kirk, and the relevance of our institution and the kind of histories of connection and comparison for writing histories of Indian constitutionalism. Now, the Constitution of India, which was adopted by the Constituent Assembly on the 26th of November in 1949, came into force the year thereafter in 1950. Already, we see Ambedkar reflecting critically on the fruits of his own labor. On November 25th of 1949, about 2 months before the first Republic Day of India, Ambedkar would participate in a debate on the third draft of the Indian Constitution, where he famously argued, and I quote, "On the 26th of January, 1950, we're going to enter a life of contradiction. In politics, we will have equality, and in social and economic life, we will have inequality. We must remove this contradiction at the earliest moment, or else those who suffer from inequality will blow up the structure of political democracy, which this assembly, the Constituent Assembly, has laboriously built up." Let us consider the enormity of the constitutional grief. To inaugurate a political democracy by eradicating a millennial order of injustice and inequality. Ambedkar argued that he and his generation had done their best to make a good constitution through recourse to a grand exercise in comparative constitutionalism. And yet he was not himself above rejecting the founding document, one that he had played a key role in birthing, and noted elsewhere, and I quote again, "I'm quite prepared to say that I shall be the first person to burn the Constitution if it doesn't serve the interest of the excluded and the marginalized." Shortly thereafter, in 1951, he resigns from his position as India's first law minister over foot-dragging over the passage of the so-called Hindu Code Bill, which sought to codify and reform Hindu personal status laws in India, which privileged the male head of the patriarchal family, and also differentiated rights by caste specificity. And he did so in order to effect gender justice and to equalize the status of men and women with regard to laws concerning marriage, inheritance, divorce, adoption. And a few years before 1950, 1946, and this will be of interest to the comparative constitutionalists amongst us, Ambedkar had written to W.E.B. Du Bois to request that he share the petition that the National Negro Congress had submitted to the United Nations, protesting American racism. There, Ambedkar had noted that the relationship between Dalits and African Americans was not only natural, but necessary. And just 4 years after he returned from visiting New York, where he was awarded the honorary doctorate in 1952, on October 14th of 1956, hardly 6 weeks before his death, Ambedkar converted to Buddhism. Ambedkar's reclamation of Buddhism as an agonistic presence and a persistent historical force thus reverberated well beyond the immediate event of conversion, where 600,000 Dalits, most of them hailing from the region of Western India, converted en masse with Ambedkar at a powerful public ceremony in Nagpur city. Though broadcast as an act of human emancipation, the conversion to Navayana Buddhism, New Vehicle Buddhism, a Buddhism of Ambedkar's own making, that took shape through the writing of the posthumously published Buddha and His Dhamma, 1957, and other associated texts, had deep political consequence. It revealed the inseparability of caste and Hinduism, and it did so through a religious critique of religion itself. All this to say that the last decades of Ambedkar's life, from Indian constitution to Buddhist conversion, were remarkable even for a figure whose public and political life had been extraordinary from its very inception. By reminding us that Justice Nagarathna belongs in this genealogy, I mean to do two, maybe actually three things today. The first is to remark on the global and comparative import of a document, the Indian Constitution, which has been described as inaugurating a social revolution from within the confines of the state. Second is to remind us of a long history of interconnections between India and the United States, and around the project, the shared project of affirmative action, and also anti-race and anti-caste activism that goes back nearly 200 years. And finally, I'd like to contextualize Justice Nagarathna's own career within this ongoing tradition, one that views the Indian Constitution as a transformative living document, which has to be mobilized in the service of civil rights and social justice. Affirmative action scholars argue that affirmative action in India was very much a domestic product produced with little guidance or borrowing from abroad. A unique kind of civil rights law that addresses caste in addition to other disabilities like race in the United States as a collective structure of deprivation and impoverishment. The interpretive leeway for courts and the state in India has depended on debating eligibility. That is, on deciding who the rightful beneficiaries of preferential treatment ought to be, right? And not through a debate around the rights of equality of opportunity and non-discrimination, right? Which is to say that compensatory preferential treatment does not have to be rendered consistent with non-discrimination, unlike what obtains in US civil rights and affirmative action law. The consequences are significant. Like race in the United States, caste too is an object of state attention. However, unlike affirmative action policies in the US, now denuded, if not disappeared, the Indian Constitution explicitly privileges certain group rights over the rights of individuals. We also find a set of constitutional provisions that have allowed for wide-ranging protections for other vulnerable communities, including the poor, women, the unhoused, and so forth. These legal interventions are under threat of erasure today. Justice Nagarathna has been a torchbearer for the preservation of this constitutional legacy of ongoing social justice. She's practiced in a wide variety of areas such as administrative law, constitutional law, commercial and family law. She's represented the Karnataka State Legal Services Authority and the High Court Legal Services Committee, and she's been appointed as amicus curiae in numerous cases. She hails from the same city I do, Bangalore or Bengaluru, though she grew up in Delhi, where her father served as Chief Justice of the Supreme Court. She obtained a BA Honors in History from the Jesus and Mary College in Delhi in '84 and an LLB from the Campus Law Center at Delhi University. She started to practice law in 1987 and was in independent practice from 1994 until her elevation as a judge of the High Court of Karnataka in 2008 and as permanent judge in 2010. As a judge of the High Court of Karnataka, she served as the president of the Karnataka Judicial Academy and president of the Bangalore Mediation Center. And she was elevated as judge of the Supreme Court of India in 2021 and is slated, as I noted, to become Chief Justice in 2027, the first female Chief Justice of the Indian Supreme Court, and has contributed to the book Courts in India. I'm going to end by noting and mentioning two major cases that Justice Nagarathna was involved in. As some of you will know, in 2016, the Indian government abruptly withdrew from circulation all 500 and 1,000 rupee notes, claiming this was a push towards a digital economy and a strike against corruption. This experiment in demonetization was a disaster, leading to a drop in GDP and massive economic hardship on the poor. 6 years later, in 2023, the Supreme Court upheld its legality in a 4-to-1 judgment where Justice Nagarathna's powerful dissent has won more attention, and correctly so, because it sought to locate responsibility and proceeded to ask the right questions. Most importantly, how and why the governing board of the Reserve Bank of India abdicated their authority over such a crucial decision. This is, I would argue, a radical, major pro-poor intervention on the part of the justice. More recently yet, the justice, together with Justice Ujjal Bhuyan, delivered a transformative judgment that nullified remission orders that had prematurely released 11 men convicted of a brutal gang rape during the 2002 riots in Gujarat that killed more than 2,000 Muslims, including the daughter of Bilkis Bano, the chief victim in this case, as well as the unborn child of Bilkis Bano, who was pregnant at the time. Rejecting an earlier judgment from the Supreme Court that led to the convict's release as being based on fraudulent information and suppression of compromising facts, the division bench led by Justice B.V Nagarathna rebuked the Gujarat government for abuse of discretion and usurpation of power. Heinous crimes against women and children required a minimum sentence of 28 years, the justice pointed out, whereas the men had been let go after 14 years, and moreover feted again after their release with garlands, sweetmeat, and photo opportunities. Bilkis Bano, who fought this case from 2002, argued that she could breathe again, and that this is what justice feels like. I think both of these judgments by the justice are reflective of a broad commitment to social justice, to due process, to the fundaments of civil rights and political recognition and dignity that the Indian Constitution provides. And it's with this that I would like to ask the Chief Justice, soon to be Chief Justice, we're all waiting for this, to please speak to us and about social justice and the Constitution. Thank you.
A very good morning and good evening to everybody. Professor Anupama Rao, thank you for your kind words of introduction. Members of American Constitution Society, the Center for Constitutional Governance, and the CEDE initiative, which has been founded by Ms. Disha Wadekar, distinguished invitees and guests, faculty and dear students of the Columbia Law School. At the outset, I must say that I am indeed honored to participate in this symposium on 75 years of the Indian Constitution. 75 years ago, the aspiration for an enduring constitution in India was seen by some as extremely bold and by others as unrealizable. But thanks to the vision of the founders of our republic, the grammar of elections and Westminster-style representative institutions have found deep roots in India. The framers of our constitution crafted a masterly document that binds every Indian who lives in the vast geographical landmass in India. Your institution has its place in the history of our remarkable constitution, for it intellectually nurtured none other than Dr. B.R. Ambedkar during his doctoral studies in economics and later when he got his doctorate in law, as he went on to play a historic role in its framing as the chairman of the drafting committee. I regard Dr. B.R. Ambedkar as a thinker who was far ahead of his times, but nevertheless had the ground realities in mind when the Constitution was ultimately drafted. I am delighted to speak and participate in this symposium for another reason. The subject of my address speaks of the Supreme Court's role in the quest for social justice, that is, in my view, the heart of the Indian Constitution. I say this because the text, structure, intent, and content of the Constitution of India envisions a peaceful revolution. As a student of history, I find the choice of the structure of the Constitution to be a natural outcome of the transformative ideals espoused by the Indian people during the freedom struggle. After all, we know that the freedom struggle was not merely a quest for political independence, but a mission of social transformation and moral and spiritual recovery. Framed by leaders who knew the pulse of the Indian society and had the vision to lead the people of India to the heaven of freedom, the Constitution sought to actualize the ideal of equality in social, economic, and political realm. By enshrining the principle of universal adult franchise, the Constitution made sure that every adult person's political decision had an equal value. This, I think, was indeed revolutionary. The bold aspirations of our transformative Constitution are manifest in its grant of rights and remedies against oppressive social wrongs such as prejudice, stigma, stereotypes, and exploitation. Certain discrete forms of exploitation, such as child labor and untouchability, were prohibited by the Constitution in the Fundamental Rights chapter, that is, Chapter 3, while imbibing wisdom from diverse constitutional orders, including the United States and Ireland. What is this constitutional vision of social justice? Social justice is an ideal that is achieved through the progressive elimination of injustice and inequity in society. It calls for transformative efforts to undo the impact of pervasive social hierarchies and past injustice. It also demands the creation of conditions of justice. Now, what are these conditions of justice? These would emerge from an active process of remedying or preventing an act, decision, or situation that would arouse the sense of injustice in the people. The special constitutional provisions and safeguards for weaker sections of the society manifest the intent to create such conditions of justice. The preamble of the Constitution pledges to secure justice, social, economic, and political, to all citizens of India. When we read Articles 38, 39, and 46, they accentuate the quest for a just social order. Their noble aspiration is to enrich the representative bodies and public service organizations with the voice and participation of the marginalized and the depressed. For instance, by granting political reservations to scheduled castes and scheduled tribes, the Constitution ensures that the members of socially marginalized groups are not excluded from the political executive and governance. In that sense, the Constitution sets a benchmark for inclusive governance and social justice. With this brief introduction, I would like to enunciate upon the ideal of social justice as enshrined in the Indian Constitution by reflecting upon the Supreme Court's role in the journey of implementation of this constitutional vision. The Supreme Court's contribution to the quest for social justice are all-encompassing. Before discussing the court's ameliorative interventions, I will briefly reflect upon the historical process through which it has emerged. Thereafter, I will discuss how its jurisprudence has preserved the principles of substantive equality of opportunity for scheduled castes, scheduled tribes, and other marginalized sections of the society. Then I will discuss the Supreme Court's progressive jurisprudence or the rights of women and sexual minorities. Finally, I will touch upon the role in realizing the goal of equal participation of the persons with disabilities and other legislations, which are social welfare legislations, and as to how the Supreme Court has interpreted them. Under our Constitution, the power of judicial review has time and again been invoked to prevent and remedy injustice. While I speak on all these aspects, I may sound a note of caveat by saying that it is only a bird's eye view of the concept of social justice and the role of Supreme Court which I am speaking about, for on each of these aspects I can speak for an entire day. But given the time limit of 30 minutes, I'll try to push in as much as I can. Such an injustice in the society is on the behalf of the state as well as the individual members of the society. When it comes to the state, it is on account of the neglect of the duties of the state, or on the other hand, as I said, as a social malaise. To borrow the fallacious expression from Justice Vivian Bose, the great jurist and judge of the Supreme Court in the mid-50s, it has been a zealous endeavor of the Indian judiciary that the Constitution should work for the butcher, the baker, and the candlestick maker, whom Justice Krishna called the little Indian, or whom we usually say the common man. The judges of the highest adjudicatory body in the world's largest democracy consider it their duty to redeem their constitutional oath and do justice no less to the pavement dweller than to the guest of the five-star hotel, in the words of Justice Chinnapareddy in Ranthir Singh. Although the Indian legal system inherited the canons of common law, the constitutional courts in India have demonstrated creativity in granting unconventional reliefs to litigants who have been victims of injustice. The fundamental right to approach the Supreme Court to enforce fundamental rights under Article 32 and to the High Court under Articles 2 to 6 of the Constitution has broadened access to remedies against injustice. Article 32 delineates the Supreme Court's role in actively creating conditions for justice. In trying to create conditions for justice, the Supreme Court takes on the burden of ensuring that the cries for justice from the underprivileged and weaker sections of society don't remain unanswered in the prevailing legal regime. What it involves is not merely a scrutiny of an unfair state action, but also an enforcement of public duties that are essential to prevent the violation of fundamental rights and to achieve social justice. This broad vision of social justice was smelted through legal innovations introduced by the judiciary in the late 1970s and early 1980s. One such innovation is through the public interest litigation, or PIL, where the doctrine of locus standi and rules of standing were substantially diluted to enable concerned citizens to seek the indulgence of the constitutional courts to remedy an instance of social injustice. Scholars such as Professor Upendra Bakshi have proposed the term social action litigation, while pointing out that public interest litigation, as it emerged in the United States, was more appropriate to the advanced capitalist United States society. PIL was conceived as a cooperative effort on the part of the awakened citizen, the state or public authority, and the court to secure social justice to the vulnerable sections of the society. This active approach of the Supreme Court is captured in the case of Husainara Khatun versus State of Bihar. The Supreme Court, upon a habeas corpus petition filed by two Supreme Court advocates, directed the release of nearly 40,000 under trial prisoners. Lest the golden key to unlock the doors of injustice remains only with people with deep pockets, the Supreme Court of India pioneered the PIL, thereby throwing open the portals of the court to the common man. PIL is the incarnation of judicial activism in its people-oriented litigative dimension. The court demonstrated a willingness to act as a bridge between life and law, to blend the structure of adjudication to the needs of the vulnerable members of the society. As a result, under trial as well as convicted prisoners, women in protective custody, children in juvenile institutions, bonded and migrant laborers, unorganized laborers, scheduled castes and scheduled tribes, landless agricultural laborers who fall prey to faulty mechanization, slum dwellers and pavement dwellers, these and many more groups now flock to the Supreme Court seeking justice. They come with unusual problems, never before so directly confronted by the court. These concerns are said to be remedied by rather extraordinary remedies. I can confidently say that the PIL movement has brought out a new dialogue on the Supreme Court's potential to deliver on the promise of social justice. It is also worth noting that at a certain point of time, the Supreme Court has had a specially constituted bench designated as the Social Justice Bench, which assembled every working Friday at 2 p.m. to hear public interest litigations and other writ petitions. Having discussed the process through which the Supreme Court emerged as the harbinger of social justice, I will discuss how its jurisprudence has heralded a process of empowerment for various marginalized communities. The provisions for reservations, or what may be called affirmative action or compensatory discrimination, are central to the constitutional goal of social justice. Justice O. Chinnappa Reddy's judgment in the case of Vasant Kumar captured the essence of social justice when he stated that the scheduled caste, the scheduled tribes, and other socially and educationally backward classes, compendiously described as the weaker section of the people, have long journeys to make in society. They need aid, they need facility, they need launching, they need propulsion. Their needs are their demands. The demands are matters of right and not of philanthropy. They ask for parity and not charity. They claim their constitutional right to equality of status and of opportunity and economic and social justice. Several bridges have to be erected so that they may cross the Rubicon. Professional education and employment under the state are thought to be two such bridges. While making reference to the conditions for amelioration, in the same judgment, Justice Venkatramaya said that as far as children are concerned, how do you ameliorate their status when it comes to the scheduled caste and scheduled tribe? He advised that the state must provide, apart from hostel facilities, free access to schools, access to textbooks, uniforms, midday meals, and all facilities which will ultimately ensure that there is parity between the children belonging to the weaker sections and the other privileged sections. Once there is a parity built up right from the childhood, then when these people become adults, the discrimination would not be there at all. In a long line of judgments, the Supreme Court has emphatically underlined that substantive and not formal notion of equality of opportunity is necessary. The 9-judge bench in the landmark Indra Sawhney's case rendered a robust and principled basis for the salutary premise of affirmative action. The Supreme Court emphasized the framers' intent to remedy real structural barriers that prevented the realization of equality of opportunity. I can go on and on this aspect of the matter, right from the cases which have come, particularly from my state, that is the state of Karnataka, in the form of Chitralekha, M.R. Balaji, etc. But in order to see that I touch upon the other aspects also of social justice, I would straight away go to M. Nagaraj versus Union of India. In 2008, the Supreme Court upheld the amendment made and permitted accelerated promotions for members of the scheduled caste and scheduled tribe community. It held that the policies for reservation in promotions can be made subject to the demonstration of compelling reasons based on quantifiable data on backwardness and inadequacy of representation. The court held that the purpose of reservation is to transcend caste, not perpetuate it. It reiterated that reservation policy ought to be framed on a more scientific and rational basis while balancing the concerns of merit and efficiency. Of recent vintage is the judgment in Neil Aurelio Noon that pertains to backward class and economically weaker section reservation in medical education. Dr. Justice D.Y. Chandrachud, as the Chief Justice then was, repelled the argument that such reservations jeopardize professional merit. He observed that merit was also acquired through incidents of privilege and the concept of merit should be defined in an inclusive sense. Just as the Supreme Court has enriched a robust jurisprudence on affirmative action, it has also safeguarded the essential economic interest of the marginalized scheduled tribe community. while ruling on the restriction on transfer of land owned by tribals under the 5th schedule of the Constitution in Samata versus State of Andhra Pradesh, Justice K. Ramaswamy reasoned that the framers of the Constitution sought to preserve tribal autonomy and culture to ensure economic empowerment and by preventing social and economic injustice to them. I shall now move on to justice for women and sexual minorities. As a vigilant guardian of the ideal of social justice, the Supreme Court has scrutinized prejudicial rules to ensure that non-discrimination and fairness emerge as the central governing principle of state policy in all spheres of public life. An instance of such scrutiny is the case of C.B. Muttamma versus Union of India in the year 1979. Muttamma was an officer in the Indian Foreign Service. She challenged the IFS rule which prohibited married women from being appointed as a matter of right and required a woman member to obtain permission before her marriage. During the pendency of the case, the government realized that it was not in accordance with the Constitution and withdrew the prejudicial rule. However, the great Justice Krishnaiah rendered a judgment finding such disabilities based on marriage to be a facet of stark bias against women and were violative of the right to equality under Article 14 because even a male employee's discharging of professional duties can be affected by domestic responsibilities. There is no gainsaying the fact that the most enduring protection against gender-based inequity is the financial independence of women. Such financial independence can only be achieved if the state makes special efforts to make public employment opportunities equally accessible to women. This was the thrust of the reasoning of Justice Sujata Manohar in Government of Andhra Pradesh versus P.B. Vijayakumar. As the second woman judge of the Supreme Court, she upheld policies that provided special reservation for women as a measure to achieve effective equality. Justice Sujata Manohar held that the purpose of special provisions enabled by Article 15(3) of the Constitution was to strengthen and improve the status of women in recognition of their social economic backwardness. The Supreme Court had the occasion to scrutinize such protectionist stereotypes in the case of Anuj Garg versus Hotel Association of India, which concerned a rule in Section 30 of the Punjab Excise Act prohibiting the employment of any man under 25 years of age and any woman in a place where intoxicated liquor was sold. The Apex Court held that instead of prohibiting women from employment in such places, the state should focus on factoring in ways through which unequal consequences of sexual differences can be eliminated. Another case of recent vintage is that of Indian Hotel and Restaurant Association versus State of Maharashtra, where Sections 33 capital A and Section 33 capital B of the Bombay Police Act, which prohibited dance performances in eating houses, permit rooms and other such places, except in 3-star and other such places, on the ground that it created unreasonable classification of women employed in bars and 3-star hotels under Article 14 and was violative of their right to work under Article 19. The Supreme Court has continued to contribute towards a progressive reform in personal law too. Subsequent to the Shah Banu case, the Supreme Court upheld in its 2001 judgment the provisions of the Act brought about in Daniel Latifi and a 2017 judgment in Shaira Banu's case. The court struck down the antediluvian practice of triple talaq. I may say that taking a note from the suggestion in the minority judgment, the Parliament has enacted the Triple Talaq Act in 2019. In Vinita Sharma versus Rakesh Sharma, while interpreting Section 6 of the Hindu Succession Act 1956, the Supreme Court recognized the right of a Hindu daughter to be a co-partner along with her brother, that is the son, in respect of division of Hindu co-partnery property. Another facet of the Supreme Court's journey in advancing social justice is the role as an initiator of reform. In this avatar, the Supreme Court of India leads the dialogue for progressive social transformation by educating the public authorities about the discharge of their duties in line with constitutional values. The landmark judgment in Vishaka led to the evolution of a grievance redressal mechanism for survivors of sexual harassment at the workplace by invoking Article 142 of the Constitution, and to do complete justice in the matter, the court pressed the obligations under international human rights law into service. An NGO called Vishaka and other women groups filed the public interest litigation before the Supreme Court to enforce the fundamental rights of working women under Articles 19, 14, and 21 of the Constitution. The Supreme Court addressed deep-rooted gender inequality at the workplace and passed the Vishaka Guidelines against workplace sexual harassment. Vishaka has subsequently received attention from the Supreme Court in Medha Kotwal Lele's case by a power of continuous mandamus, and in 2013 took note of the grievance that the complaints committees were not constituted pursuant to the Vishaka Guidelines, and therefore consequential guidelines have been directed by the central and state governments for significant amendment to the civil service rules and industrial employment rules. Ultimately, the whole object is to ensure that the judicial order passed in Vishaka and the subsequent enactment of the Prevention of Sexual Harassment of Women at the Workplace Act 2013 are implemented in their true spirit. Recently, the Supreme Court held an occasion to review the implementation of the law in Aurelio Fernandez versus State of Goa, where it issued further directions so that every aggrieved woman can take recourse to the legal remedy. This is in Civil Appeal number 2482 of 2014. Therefore, in many ways, the Supreme Court's transformative jurisprudence has bridged the gap between legal justice and social justice. I had an occasion to deal with a case, namely Prabha Tyagi versus Kamlesh Devi, in this regard. The matter arose under the Domestic Violence Act, and the question was whether a lady had the right in a shared household, even in the absence of a domestic violence. The said Section 17 of the Act fell for consideration, while holding that the right to reside was interpreted not to be conditional upon the existing of domestic violence. I attempted to provide essential relief to women in difficult life circumstances. It was held that the right to residence was an independent right and a remedy, so that young indigent brides are not left remediless if they elect not to litigate a case of domestic violence. More recently, the Supreme Court scrutinized administrative requirements rooted in stereotypes about women's ability and physiological characteristics in the case of women short service commission officers. In Lieutenant Colonel Nitisha, Justice Chandrachud stated, and I quote, "It is not enough to proudly state that women officers are allowed to serve the nation in the armed forces, when the true picture of their service conditions tells a different story. A superficial sense of equality is not in the true spirit of the Constitution and attempts to make equality only symbolic," unquote. In a similar vein, recently in a judgment which I happened to author by way of a concurring opinion, namely in the case of Association of Old Settlers of Sikkim versus Union of India, I held that when a benefit is being given to a Sikkimese individual, which would include individuals of all genders, a certain category of married Sikkimese women to non-Sikkimese cannot be deprived of the said benefit of exemption from income tax. When it comes to transgender persons, social justice has not been recognized as such for them until the court recognized it in National Legal Services Authority versus Union of India in the year 2014, when the court said that the right to self-determination for transgender persons is an instance where it has led the complex social process of inclusion. While crafting the range of remedies for the transgender persons, it held that they were a socially and educationally backward class of citizens who ought to be eligible for affirmative action in education and employment besides welfare and other policies. It was held that the state is bound to take some affirmative action for their advancement so that injustice done to them for centuries could be remedied. This judgment has led to the passage of the Transgender Persons Protection of Rights Act 2019 by the Indian Parliament. In 2018, in Navtej Singh Johar versus Union of India, the Supreme Court affirmed the inherent right and dignity of all citizens belonging to the LGBTQ community by striking down the law that criminalized same-sex relations. The judgment has led to a progressive social discourse or the inclusiveness of the inclusion of the LGBTQ community in the mainstream society. At this juncture, I must highlight one of the path-breaking initiatives of the Supreme Court, which is to set further the cause of gender inclusion and justice. The publication of the Handbook on Gender Stereotypes would further deepen public trust by correcting pernicious anti-woman prejudice that continues to haunt the legal profession and women's quest for justice through the judicial process. What about the Supreme Court doing some justice for the persons with disabilities? The court's interventions for the persons with disabilities have had the effect of adding substance to the right to equal citizenship. In Union of India versus National Federation of the Blind in the year 2013, the court directed union and state governments to comply with the constitutional obligations to faithfully implement reservation policies for persons with disabilities. In the case of Vikas Kumar Yadav, a civil servant aspirant who had sought the assistance and facility of a scribe, ameliorative role of the Supreme Court was seen in providing such a facility. The law under challenge was the Civil Service Examination Notification, which restricted accommodative facilities like scribe to be made available to persons with blindness, locomotive disorder, and cerebral palsy. Other judgments, such as Avni Prakash versus National Testing Agency, concretized the conception of reasonable accommodation as a matter of right and not charity by reasoning the denial of reasonable accommodation would amount to discrimination on the ground of disability. What about the workers' rights and social justice for them? The case of People's Union for Democratic Rights versus Union of India 1982 3 SCC 235 is emblematic of the Supreme Court's active efforts to enable marginalized groups that were too disempowered to be able to directly participate in making claims against structural injustice. The Supreme Court emboldened the struggle against injustice suffered by persons who are employed by contractors in building, and it said that the state was duty bound to implement the law. We recently have the act where the contractor is duty bound to make deposits for the benefit of the employees or the workers who work on the construction sites. The said act has to be implemented in its full spirit in order to ensure that this migrant labor who go from site to site, who stay in tin sheds and in tents, but build palaces and huge towers, are given their due under the Constitution. The Supreme Court also emboldened its struggle against injustice suffered by impoverished sections of society by recognizing that the right to livelihood is a part of the right to life in Olga Tellis' case. It is a judgment authored by Justice Y.V. Chandrachud. We have the Manrega Act, but the emphasis again is as to how far that act is being implemented and whether the persons who are employed under the scheme are being paid their dues rightfully and in time. The Supreme Court's jurisprudence on social and economic rights has meant that access to social benefits and welfare is conceived as a right and not a form of government largesse. I must say that no government is providing a largesse where it is implementing the goals of the Constitution, which are enshrined under the directive principles of state policy in order to bring about a society and justice on both not only political justice but social and economic justice. The judicial acknowledgement of entitlements in the socio-economic sphere has deepened the protections of citizens in the era of economic liberalization. These judgments have contributed to the enactment of progressive statutes such as the Right to Education Act 2009, the National Food Security Act 2013, and the Street Vendor Rights Act 2013. In the context of granting essential relief against inequitous economic exploitation of working classes, the relatively recent judgment in Gujarat Mazdoor Sabha versus State of Gujarat is apposite. In the background of the COVID-19 induced national lockdown, daily working hours were increased from 9 to 12 hours, overtime payment was halved, and weekly working hours were enhanced from 48 to 72 hours. The state of Gujarat issued a notification which exempted all the factories from adhering to a set of workers' rights such as fixed working hours, rest intervals, and overtime pay. This was sought to be justified on the ground of the public emergency which prevailed owing to the COVID-19 pandemic. Finding that mere financial exigencies do not qualify as an internal disturbance, the court demonstrated that the manifest unfairness in diluting protection which had emerged from a recognition of the inequality of bargaining power between workers and their employers could not be given an imprimatur. The court underlined that such protections were constitutionally embedded in Article 21, right to life, and Article 23, right against forced labor, and could not be reduced to mere paper tigers in such time of an emergency such as during the COVID-19 pandemic. The court's insistence upon satisfying the four-pronged proportionality test heightened the need for cogent reasoning by the state when its acts impair the rights of citizens. In the context of the Motor Vehicles Act, which provides for compensation as a social welfare measure and as a social welfare legislation to the victims of road traffic accidents, while interpreting the word legal representative in the case of Gujarat State Road Transport Corporation versus Ramanbai Pratapbai in 1987, the court held that in an Indian family, brothers, sisters, and brothers' children, and sometimes foster children, live together, and they are all dependent upon the breadwinner of the family. And if the breadwinner of the family is injured or killed on account of a motor vehicle accident, there is no justification to deny them compensation by relying upon the provisions of the Fatal Accidents Act 1855. This interpretation is also in line with the Supreme Court's quest for social justice under a social welfare legislation. Through its procedural innovations, its institutional independence, and the broad sweep of constitutional rights in the Indian Constitution, the Indian Supreme Court has made a difference to the lives of those most in need. This is because the judges of the Supreme Court have always been conscious of the goals which are envisioned in the Constitution of India. The above discussion of the Supreme Court's role in advancing the cause of social justice is a testament to the fact that it is an institution that is responsive to the aspirations of a rapidly changing social milieu. I am assured that in the decades to come, the Supreme Court as a composite institution would serve we, the people of India, in a more effective manner and steer the chariot of social justice towards our constitutional destiny. For that, we must believe in our Constitution. We must believe in the preamble, the chapter on the fundamental rights and the directive principles, the goals that it has envisioned, and the fact that it is eternal and all enduring. With these words, I wish this conference the very best and hope that the intellectual deliberation here fosters and furthers the spirit of reasoned dialogue that lies at the heart of Indian constitutionalism. I once again thank the organizers of this conference for giving me this opportunity to share a few of my thoughts on the social justice aspect of the Supreme Court under the Constitution of India. Thank you and namaskar.
Thank you, Justice Nagarathna, for those really thought-provoking remarks and the lecture. You have literally handheld us through 75 years of Supreme Court equality jurisprudence. And you have demonstrated how the Supreme Court, the Indian Supreme Court, is not just an instrument of the Constitution, but is at the very heart of the Indian Constitution. I would now open, if you are okay with it, we have a few questions, just two more questions. I know we are a little over time. But I would invite Ravi Prakash to the podium to ask his question to Justice Nagarathna, and then he will have a question from Professor Ram.
Good evening. Thank you for the wonderful lecture and your words on the role of Supreme Court of India in transforming its social and political economy, and particularly emphasis on the social justice and different target groups. Recently, I have been tracking down the judgments by the Supreme Court of India and the United States Supreme Court. It's also one of the disturbed feature of both the courts nowadays is with regard to the emerging jurisprudence of dignity, autonomy, and choice vis-a-vis reproductive rights of women. Your ladyship was also the author of a division bench judgment by the Indian Supreme Court, wherein yourself has upheld those rights as a pro-women right, where the mother has a right to decide and take a conscious call upon her right to pregnancy. However, with the judgment of Dobbs, and again the way the Indian court, particularly that judgment has developed before a three-judge bench, it was overturned within a week, in a very dramatic manner, and gave a judgment finally pro-life of the fetus, and the women, that particular lady was prevented from getting the abortion. So my question is, how do you see the Indian legal system in coming days to responding to such a scenario, whether it is going to be a pro-life of fetus or pro-abortion in light of new emerging technologies facilitating such reproductive rights of women?
See, this dialogue regarding pro-choice and pro-life is a dialogue which has come up after the judgments of the Supreme Court, which in October 2023. Personally speaking, I don't believe in such kind of pigeonholing the concepts of pro-life and pro-choice. Ultimately, it is the facts of the case which gives rise to a judgment one way or the other. Every case which comes up regarding termination of pregnancy must be viewed in the context of the facts and the surrounding circumstances in which the lady is placed and she is asking for a termination of a pregnancy. Now, we all know that we have in India the Medical Termination of Pregnancy Act 1971. If a pregnancy is to be terminated within the scope and ambit of the provisions of that act, then there is no difficulty at all. It is only when pregnancy is sought to be terminated outside the scope of that act by approaching the Constitutional Court, either under Article 226 of the Constitution or under Article 32 of the Constitution to the Supreme Court, earlier in the High Court and or the Supreme Court, as the case may be, that this debate begins. But if we view the plea made by a woman in the context of how she is placed, what the facts and circumstances are, then this debate would actually fade into insignificance. Of course, the health condition of the fetus has been given importance now. But let me say that if it is a case of a minor child seeking an unwanted pregnancy which has arisen on account of a sexual assault, whether the question of pro-life would be really the factor to be considered, or the question of the circumstances in which the minor sexual assault victim is placed to get rid of an unwanted pregnancy is to be considered. Ultimately, the discretion has to be exercised by the constitutional courts depending upon the facts of each case and the circumstances in which the woman is placed. On the other hand, let us say there is a lady who wants termination of pregnancy, let us say for the reason that she wants to travel abroad, or she wants to take up a job, or for any other such reason. Whether the court would exercise discretion in such a case in the same way as it would exercise discretion in the case of an unwanted pregnancy of a minor child, a minor girl who is a victim. I feel that this debate must ultimately yield to the facts of each case, and discretion must be exercised by the High Court or the Supreme Court, as the case may be, on the basis of the facts that emerge. This is how I would view it. And therefore, let us not polarize the debate into only pro-life or pro-choice. Thank you.
We take one question from Professor Rao.
Yes.
Thank you so much again for providing a sense of the commitments to substantive equality that are both enshrined in the Constitution and the work of the Supreme Court in interpreting as widely as possible a set of pro-poor, pro-women, pro-SC/ST, pro-worker laws that are instantiated by the Constitution. My question for you was actually to ask if you might say a little bit about, as you are on the cusp of becoming the first female Chief Justice of the Supreme Court, what are the conditions of women in law? What would you say about gender justice within the realm of legal education, but also legal representation? So I guess it's a little bit more of a question for you to speak about your own experiences and in some sense to reflect about what kinds of conditions exist for greater representation for gender and sexual minorities to enter the legal profession, and whether that would make a difference in the ways in which we think about legal interpretation and the work of the Supreme Court in the years to come.
See, your question is in two parts. The first part is with regard to women in the legal profession. I must say that with the passing of the decades, women in the legal profession have come to stay. They have made a real mark in the legal profession, both as lawyers, advocates, and as well as, I believe, on the bench. Today, women in the bar or on the bench cannot be ignored. But I must say one thing, that in order that women are not ignored in the legal profession or on the bench, they must put in more effort, I suppose. This is the feeling I have, that if I should not be ignored by being a woman in the legal profession or on the bench, I must make a mark. For that, I must put in more effort. I don't know whether the men in the legal profession or my male colleagues would have to put in that much effort. The effort is not in order to get a bouquet or a pat on the back, but simply to say that, look, I am here too, and I am not an adjunct. I am part of the entire system, and I have a right to contribute to the justice of this country in the same way as any male judge would. And therefore, I think psychologically, if we think that we need to put more effort, the effort is worth it. Then secondly, with regard to gender justice, the time has now come when we can say that the doors of the courts at whatever level they are open towards gender justice. Of course, it would all depend as to the facts of each case, the kind of relief that they ask, and what the courts could do within the four walls of the law for ameliorating the status of women or the LGBTQ community, etc. Today, nobody can say that I will not recognize the rights of various sections of the society. Those days are gone. With the passage of time, the courts are always interested and in ensuring that newer rights are enunciated in order to see that the constitutional goals and the protections of equality and other fundamental rights reach to all sections of the society. Therefore, I think that women lawyers in the legal profession would really help in ensuring that there is gender justice. By this, I am not saying that the men in the profession are totally ignorant about it or are not interested in ensuring that there is gender justice, or that the male judges are not. There are many male judges who are also interested in seeing that there is justice done to all sections of the society, including women. But the time has now come where I would say that we have made our mark in the legal profession as well as on the bench, and that we cannot be ignored or considered to be an auxiliary or an adjunct in the entire system. Thank you.
Thank you, Justice Nagarathna. I think you are truly an inspiration for women in law like me. You have really demonstrated how the Indian constitutional regime is about a seat at the table for all marginalized sections and all marginalized groups, whether it's women, whether it's caste marginalized groups, whether it's sexual minorities or religious minorities. I would really like to thank you for taking time out of your busy schedule to join us here for this very important event. On this occasion, I am reminded of an observation made by the Indian Supreme Court in a judgment dated 2018. The court has noted that if we truly are to emerge out of the grim shadows of the society which has subjugated groups of our citizens under the weight of discrimination for centuries, it is time that the Indian Constitution is allowed to speak, as it can only do so in a forthright manner as a compact of governance for today and for the future. Once again, thank you, Justice Nagarathna, for this amazing lecture. Your wisdom and expertise will surely guide us in our ongoing pursuit for equality and justice. I would also like to express our gratitude to Professor Rao for your thought-provoking remarks and of course your question, which was really inspiring. A special word of thanks to all our co-sponsors without whom this event would not have been possible. And last but not the least, I extend my heartfelt thanks to all the attendees and all the questions that have come our way. Thanks for joining us. See you tomorrow again. We will be joined by Justice B.R. Gavai tomorrow at 12:10 p.m. He'll be joining us in person in Jerome Green Hall. Thank you. Thank you.
Thank you, Ms. Disha. Thank you. Namaskar.